everybody. Welcome to this edition of DeSimone on Deals. This is the Exit Strategy podcast where we talk with different experts in the field to help business owners prepare for their ultimate exit. Whether they're planning to or not, this is to make sure that they get the most value and the best possible outcomes in the situation. Today, our expert and our guest is Sally McDonald. She is the current chair of litigation, and I joke with her because every time I see her, I say, "You do litigation," and have a good laugh, even though she's probably one of the best litigators that you'd ever meet out there. You might say to me, why is Sally McDonald, the chair of litigation at Cameron Middleman, talking about exit planning? And I'll tell you, litigation can screw up a deal, whether it's pending litigation or it's shareholders fighting with each other, customers fighting with their client, with the company. All kinds of litigation can cause problems with a deal, either kill the deal or hurt the value of the deal, reduce the value of the deal. So that's why I brought in Sally, because whenever we are out talking, networking or socializing with other networking friends who they were networking partners, but now we're a big group of friends that go out and just talk about stuff. Some stuff we can share today, some stuff we can't. So I wanted to bring her on because she has some great stories, and I think more importantly, once we hear her stories, we're going to talk about what could have been done to prevent that story from ever happening so they wouldn't have been in litigation. So without further ado, let me bring on Sally. Sally, why don't you fill in the blanks of what I didn't tell everyone they should know about you?
Thank you so much for having me, Greg. This is fun. Great to be on your podcast. Yep. So you described the fact that I'm chair of the litigation department at Cameron and Middleman, which is a Providence-based law firm, approximately 50 employees. I say that my specialty is business litigation, which is a pretty big umbrella. But that can include employment litigation, construction litigation, estate and trust litigation, but certainly in general, a lot of litigation that the typical business could run into at some point, whether they're being sued by an employee or there's fights among their shareholders. Just a variety of business lawsuits is really what I've handled in my career.
Awesome. And I know that you're like the she's got this Midwest charm. She looks really sweet and nice, but if anyone watched her in court, she's a stone-faced killer, and you don't even realize that the knife's in your back and you're dead because of this nice smile she has. Just disarms you. Um, so this is why I like having different types of guests, because you always learn different things when you talk to people that have different perspectives or look at problems differently than you do. As I was preparing for this podcast, and when I say prepare, I was making quick notes on a notepad that's right here. Um, Sally brought up an issue that comes up all the time, but was not on my radar screen to talk about today. It's the idea of pending litigation. Whenever you go through a transaction and you go through diligence, someone actually comes in and says they've made an offer and you've accepted it. Now you got to like show them everything, and let them know all the warts and let them make sure and verify everything that you've promised them in the past that it's all true. One of the questions always is there any pending litigation? And depending on what the litigation is and what the potential resolution is and what the status of it is, will impact whether this deal closes or if the value of the deal goes down, or there'll be um, holdbacks or escrows on how to handle that potential ongoing litigation. So, Sally, why don't you tell us a little bit more about how you look at pending litigation in these type of situations?
Sure. So I come at it, I'm not an M&A attorney. I come at it differently being a litigator. What I often hear from my clients is, oh my gosh, I'd love to sell my business. I'm getting towards retirement age, or I just don't want to do this anymore, but I don't know how I can do it with this litigation pending. We've got to get rid of this litigation. And unfortunately, that's very often easier said than done. Litigation is a painfully slow process. It can be quick, but it can also take years and years. Particularly where I practice in both Rhode Island and Massachusetts. Massachusetts and also federal court in Rhode Island tend to be more strict with their tracking orders in terms of making parties do things by certain dates. But in Rhode Island State Court, there's not much of that. So, I mean, litigation can be dragged up for a long time. And so it can be really problematic if someone wants to go sell their business. There are ways around it, both in terms of trying to get rid of the case and also working with a potential buyer in order to deal with that issue. So sort of starting with the first piece, one thing people sometimes don't realize about litigation is that you can put forth a settlement offer from day one up until you're on the eve of trial or in the middle of a trial. You know, you can always make a settlement offer. And sometimes that just makes sense. If you're sure you want to sell your business, you don't want this hanging over your head anymore. Maybe it's worth paying a little bit more money than you feel like you should just to get it resolved. And that can be done in an informal way between counsel, just exchanging offers back and forth. Or parties might want to try mediation. Greg, you and I know a number of good mediators
Right.
within our networking group who can sit down the parties on both sides. And the job of a mediator is really to just try to bring the parties together to settle. They're, you know, the mediator's not trying to decide who's right or wrong, and they don't have the power of a judge or an arbitrator to determine who's right or wrong. It's just a neutral party going back and forth saying, look, this is going to cost you a lot of money to litigate this. It could go on for years. It's not good for either of you. How can we resolve this today? So there's always opportunities to try to settle cases before you get to trial. And honestly, in my area of practice, 95 at least percent of cases do settle at some point before trial. So you might as well try to do it early. You know, there's no harm in that.
And you need the threat of going to trial to force someone to actually settle, because if there's never a threat of a trial, then it's
Yeah.
just I can just wait out until like the right opportunity, where if someone's more desperate than the other, then they can take advantage of the situation. Is that true?
Oh, 100%. So even though we know that 95% of our cases are going to settle, we prepare for every single one of them as if we're going to trial, because first of all, you just never know which ones will end up going to trial. And in my experience, it's never the ones I thought would go to trial. It's like, you know, so this sort of surprises me which ones end up ultimately going to trial and don't settle. So you have to prepare. But also, I think lawyers who are not prepared to go to trial really do demonstrate weakness. I know for a fact that certain insurance companies will track what lawyers go to trial and how often. And if they figure out that you're the kind of lawyer who just bluffs and acts like you're going to go to trial, but you don't, then you're not going to get as good of a settlement offer for your clients because they're not going to take you seriously with your threat of trial. So yeah, that's definitely true.
You meant as you were telling, going through the process, it struck me that it's probably two different time frames that create leverage or lack of leverage. There's you have a situation, you know that you want to sell the business, but you haven't started the process yet.
Right.
The other one is you already sold the business,
Yes.
either a new issue comes up or you have an unresolved issue that's overlapped it.
Yes.
Tell us about, let's start first. Like, okay, you're thinking about it, you know that you're someone's my age, they're 56, and they said, between 59 and 62, I want to be done with I'm going to keep working forever, guys, so don't worry, I'll be here for you. But a lot of people want to retire between, like, say, 59, 62, 65. They know they're starting to that process. They have this a lawsuit or a claim against them. Um, what should they start doing to eliminate or reduce or mitigate the impact of this type of a claim?
Right. In a lot of ways, litigation is totally unpredictable, right? And you don't know. This is something that comes up a lot. Clients will say to me, "How much is this going to cost?" And I will tell them, "I have no idea," because when you start a lawsuit, I could send a demand letter and threaten someone on the other side, and they say, "Oh, we're sorry," and pay money immediately, and it's over. Or, like I said, it could be dragged out for years. So I think you have to start looking at the issue of the litigation as my former boss would say, is like a hole in the roof and it has to be fixed. You sort of remove your emotion from it and you say, okay, this is a problem. We need to deal with it. Maybe we believe we're 100% right, but what would make business sense for us to pay to just make this go away? You know, we won't have to pay our lawyers by the hour anymore. We can end all this and then we'll have a cleaner sale if we go to offer our company for sale. But I think there's also, it's important to know there's ways around it if you are dealing with a party on the other side or a lawyer on the other side who's totally unreasonable. Like, let's say they have a terrible case, but they're not going to settle, unless they have millions of dollars. Well, then you have to deal with it. But there's ways I think you can deal with it in the sales process. And you, I'm sure, know more about this than I do. But through due diligence, you can put everything on the table. You can say, okay, here are the facts. This is what's going on. We believe we're right. We have lawyers who have told us we believe we have a good case. And what we can do is agree to indemnify you. So you could have a clause in the agreement that says, look, we're going to continue to litigate this. We'll continue to cooperate in it. And if ultimately there's a judgment against the company, we'll be responsible for that. And we'll put money into escrow, in the event something like that happens. Or yeah, I'm sure as a corporate lawyer could explain this better than I could. But
Right.
there are things you can do to make it less problematic. I think a lot of times what people are afraid of is things they don't understand. And if they say, well, there's this big lawsuit and I don't understand anything about it, of course you don't want to buy into it. But I, as a litigator, if you told me I've got this litigation pending in Massachusetts Superior Court, I could find out a lot about it just from the public records. I can go online to the docket sheet, see everything that's happened, see all of the pleadings, and make an assessment from that of the relative merits of the case from my perspective. And additionally, if you can find out what settlement offers have been exchanged to date, that's a big thing because
Is that a public record?
not necessarily. So that would probably be part of the due diligence process. You'd want, if you're the seller, you want to explain that to your potential buyers to say, look, they've said they want $500,000. We've offered $250,000. Well, at least now the potential buyer has sort of a range that they can estimate within which that might be what this problem is worth. And if if you think about it, let's say you went ahead and just said, okay, I want to get rid of this litigation so badly, I'll pay the $500,000 to get rid of it. Well, that's $250,000, almost comes off of what money you could have ultimately had at the end of when you sold your company, right? So
Mhm.
it's not always smart to settle your case.
Yeah.
Sometimes you want to keep litigating it. So I think I would think being very open with the potential buyers about what the litigation's about, why you believe you're right, and why you haven't settled it, and offering, that they have their own attorneys look at the case and evaluate it, I would think would be really helpful.
You said a few things in there that I thought were interesting and I think should be highlighted. You talked about it being unemotional and fixing the hole in the roof.
Hmm.
I think that's huge. I think a lot of times when you get, I mean, I'd imagine I haven't been sued. I've been around it, but not the bullseye. I should knock on
Hmm.
wood. Um, but taking the emotional, because I guess imagine it could be very emotional. Like you get a claim against you, and you're like, I didn't do anything wrong, or my employees didn't do anything wrong. This is frivolous. But taking the stepping back and saying, okay, let's unemotionally, what is the right thing for us to do? How do we evaluate? I think that's great advice. And whether it's litigation or it's should you hire someone, should you get rid of someone, should you sell or not sell? Like I think being unemotional about it and saying, okay, let's look at this as a transaction and what makes the most sense. I think that was great advice. But
Yeah, and I'll tell you, Greg, like that's really harder than it sounds when
oh yeah.
you can imagine, one of your employees who you think you've been wonderful to for years sues you for something that you didn't do and is really, offensive to you that they would even consider saying you would do such a thing. To just say, okay, I'll write a check to get rid of them. I mean, that's not an easy thing to emotionally get over, but I think when you're in business, sometimes you do have to put your emotions aside and say, but what makes the most sense for my business and forgetting how I feel about it. And sometimes paying people to get rid of frivolous lawsuits at times is worth it.
And I agree because I've seen that happen. I guess one of the counter arguments I've heard, and I get this counter argument too, is but if I am known to settle, does that mean
Right.
other people are going to say, okay, just sue them because they're going to settle because they don't want the issue? How do you balance uh settling for the because it makes the most business sense to creating a not creating a position where you become a target because people know you settle?
That's something that a lot of my clients really worry about. And I have one of my very best clients. He's a great guy. Um, and he absolutely will not settle frivolous cases, and almost to um, a point where it doesn't make business sense, where he's paying $100,000 to litigate a case he could settle for $10,000. But he will do that because he's trying to send a message exactly that. I don't pay frivolous lawsuits. I don't settle cases. My lawyers will fight with you forever. Don't sue me. And that's another approach to take. It can be an expensive approach. You have to be kind of
Mhm.
successful to have the money to be able to fight on principle. Not everybody has that money to fight on principle, and you're also, could be using the profits of your business that you could be using in better ways. It's hard for me to say truly how much people are really aware of whether people settle cases or not. I think people feel like everyone knows what they're doing, but I'm not sure that's always true.
Yeah.
But it's really a personal decision, and people do absolutely decide that they want to fight everything on principle to make a point that they're not the kind of person who settles.
The other part I think I liked what you talked about, as I'm big on this when I'm helping people plan, is define the gap, define the problem, define the issue. Um, I think the unknown is what will scare an investor or a buyer off because they have to write a check. It's not like you're buying shares in what I'm dealing with. It's not like you're buying shares in a public company and like, you know what? I shouldn't have bought this company. You just put in a sell order and you get your money back, whatever's left of the money, 2 or 3 days later. Um, if you decide you made a mistake buying a company, well, you're probably stuck with it for another year because you got to put a book together, market it, find buyers, go through the whole diligence process.
Mhm.
So there's a lot more risk involved here, but when you can define, and so the unknown is scary, and that either reduces price, creates more structure. When I say structure, it means escrows, deferred payments, contingent payments, or it just kills the deal because it's just
Right.
too uncomfortable. So I love that process. How do you help your clients? I mean, you gave a quick example, but how do you help your clients? Like, hey, let's define what this problem is. So, and what the maximum, what the likely, what our different contingencies are, so they can get their arms around and hopefully become a little bit less emotional when they're making these decisions. Because that would, I think, translate when you're having conversations with a potential buyer.
For sure. Absolutely. I think so. First, what we try to do for our clients is be really honest with them. And a lot of times they don't like to hear it, where we'll say, okay, hey, this is what we think of your case. And most often, no case is perfect. You might feel like you're 100% right, but we might say, yeah, but you know what? You didn't put that in writing, and that's problematic. Or it's kind of a he said, she said situation in this regard, and that's problematic. So we try to be really honest with our clients about how we value the case, even if it's not what they want to hear.
Right.
And then that can help you make an educated decision about what you're going to do with regard to the case. I also think, too, the nature of the case really makes a difference. So, is it the kind of case that makes your company? I think my cat's going to walk into the frame here. Sorry.
Yeah. I can see shadows. Yeah.
You can see that. The I should have put these guys downstairs. Um, is it the kind of case that makes your company look bad? Do you know what I mean?
Yeah.
A potential buyer looks at it and says, "What have you guys been doing?" It looks like
Right.
when I look at the discovery in this case, when you open the books to me and show me everything that's going on, it looks like you guys didn't handle things very well. What else does that say about how you've been running this company? And what else do I not know? Right. So I think the if it's the kind of case where you can kind of easily explain it to potential buyers and say, look, it's a stupid case, we just don't want to settle it yet because they're being unreasonable, but we'll agree to indemnify you. We'll shift the risk to us.
Hmm.
Or you convince them, look, they've only demanded X amount of money. It's not that much money in the worst case scenario. You just take on that risk yourself and we'll help you as witnesses or whatever it is.
Hmm.
Mm, I think it's a case, it really is a case by case basis of what kind of litigation you're dealing with, how it's what the optics are going to be to a potential buyer, and then also just the personal seller's, um, as we were discussing, willingness to spend money or potentially or lose money even when they believe they're
Yeah.
correct.
I think that's a great point, is the type of case and what does it say about the control of the business and the management of the business. I
Mhm.
agree. I see certain pending litigation come up, and I'm like, yeah, okay, this happens. Um, your truck driver backed into a post, uh,
Right.
and whatever. But there's other ones you're like, okay, this is like the fourth employee claim.
Mhm.
Three different managers are being named in different cases. I'm like, what kind of culture is there? So like, I think that digging into it, understanding is there a theme of litigation? Is it targeted at a person or is it a cultural thing? What to your point, what does it say about your company's culture and management style and decision making that may lead to more of these type of claims? Because that is what the buyer's looking at. Like, what am I getting after
Mhm.
I write the check? What am I getting?
Right,
I think that's a
particularly
great point.
if you're buying, let's say, a company, and to your example, you've had all of these lawsuits from former employees. It's like, are we purchasing a company with a bunch of disgruntled employees that like
Mhm.
all hate the company? Is that what we're getting into here? Where as opposed to your other example, a truck backs into something. Well, first of all, like you said, these things happen. Nobody's really at fault most of the time in any major way. And most often, companies will have insurance company or insurance coverage for those. So it's
Mhm.
like if something like that happened at my office, I wouldn't even really think about it because I just hand it over to the insurance company and say, okay, we have coverage for this, deal with it. That's a whole different story than um, a big piece of litigation where there's no insurance coverage for it, and ultimately the company could be responsible for it. I've had clients where they sort of be careful not to identify anyone, but they've done so many things wrong that they had just tons of litigation, to the point where, if all of these cases were successful, the company would go down. I mean, that's a big difference from just, the things that happen here and there. People run into trucks.
So I think that's I think was a great point you brought up is the it's not just the value of the value of the litigation or what the cost could be is what does it say about your business? That was a great point. Um, one of the things that comes up a lot, we talk about pending litigation. But there's one that I see a lot, and I get involved with, unfortunately, too, is shareholder just my dog is driving me crazy.
Well, Lisa's not just my pets.
Yes. No, she's a I have a very big puppy. She's about 15 months old and she's very protective. There's probably a rabbit or a squirrel in that tree, and she is mad that she's in the house. So I
Oh,
apologize for everyone listening to that.
no worries.
Um, but I get involved with a lot of shareholder disputes, which again kills deals because you can't. One is it makes it more expensive for them to because I can't have a team conversation like here's what we're going to do and how I market. We're going to all work together and maximize your value. I am
Right.
separating two people. I can't talk to them at the same time. They have different perspectives. Um, sometimes I agree with one party versus the other. Sometimes I like both parties and I just don't know why they're fighting. But it is definitely a problem.
Oh, sure.
How do you see or deal with or um, let's start with the back end. I know you have a solution to this. Uh,
Yeah.
but let's talk about how do you deal with these type of situations when the shareholders disputing each other, whether it's I want to sell and you don't want to sell, or you taking
That's
too many profits. You're not putting as much effort and taking more of the profit than you should. And how do you deal with that type of stuff?
Sure. So I've had way too many cases like this, that it happens a lot with family members or good friends that go to start a business together.
Hmm.
They say, we're going to start this business. Everything's going to be amazing. We're going to make a ton of money. And we don't have to like over document this situation because we're pals or we're family members. It's no
Right.
big deal. Right. And um, whereas what anybody should do when they're starting a business is go to a corporate attorney and have proper documents put in place, an operating agreement or whatever the appropriate document is, for your kind of business, that says, okay, in the event things don't go perfectly, and in the event at some point, somebody wants out, somebody wants to sell, somebody disagrees on a major point, um, there should be documentation that explains what happens in that situation. And I'm not the corporate lawyer who can tell you exactly what those documents should say. It might be different in different companies. But at least then there can't be huge litigation over it if it's already been laid out in a contract. You know what? If one
Mhm.
person wants to sell and the other one doesn't, then we're going to sell. You know, something like that. Then there's
Yeah.
no litigation. There's nothing to fight about. But the worst fights I've seen in businesses were 50-50 shareholders with no operating agreement. And then what happened in two cases that I had recently that were interestingly, both were very successful businesses. Ironically, both of them ended up in receiverships because what happens is if you have two 50-50 partners and there's no way to determine what happens when they disagree, the court will just say, okay, we're going to give it to a receiver. We're going to sell the business. We're going to sell all the assets. And if you want to buy it out of the auction, you can do that, either one of you. But obviously, you guys can't make this work. And that's pretty sad when you're dealing with like a company that was successful. I mean, that happens.
So then just for perspective for people, these aren't hard and fast numbers, and Sally, if you see different, absolutely chime in. If you go into receivership, you're basically selling off your assets at liquidation value, which at best might be current fair value. At worst, it's going to be at 10, 20 cents on the dollar, or whatever people can get because they know that has to be sold. Versus when you sell a company that's a going concern and working and not through a liquidation scenario, you're probably talking about 10, 20, 30 times more of value.
A hundred
So,
percent. Yeah,
so it's not like, oh, I have a $10 million business, I'm going to get eight. You might have a $10 million business and get 800,000.
for sure. A perfect example of both of the worst fights I ever saw between 50-50 shareholders with no operating agreement were restaurants. And when you go to sell the assets of a restaurant, like they're not worth anything. Like
Right.
the refrigerator when you bought it was $20,000, but to sell a used refrigerator from a restaurant, you might get, you know, a fraction of that.
Right.
So, whereas if you had been able to agree, we're going to sell this to someone else, you know, people will buy the whole restaurant and all of its contents for, you know, much higher value than what you could, you know, break it apart for. But if one party adamantly says, I don't want to sell, and the other one says, I do, what can you do? You just have to break it up so that the value of the business goes to the parties
Mhm.
equally. So it's to backing up, I think this was part of your question as well, to say, really having these conversations with your business partners well in advance of the time that there's any problem, just in general, and then documenting it with a lawyer. I mean, I think I see that every day and think, man, I have a corporate department at my firm, and if you just would have visited them, you would have none of the reasons to visit the litigation department that you have.
I was second. This is a little plug for Sally's firm. I've dealt with some of her corporate people, and they are great.
Mhm.
And I actually agree with the general sentiment is ignoring a problem, hoping it gets better, because
Mhm.
you don't want to involve a lawyer because you don't want to pay the fee. I think is really not sound judgment, and it will never solve the problem. Um, to my question, I feel like I'm one of those old school reporters where I'm going to talk about for 30 minutes and then give them that one short question. Um, so you can have an operating, you can do all this documentation planning, you could still end up in litigation. How different is a claim or litigation when you have an operating agreement and a lot of the scenarios are already kind of defined versus a 50-50, we'll figure it out when it happens in the future. How different is that scenario for the parties?
Night and day, night and day. So, elaborating without giving away too much information on one of these fights it was two friends who started a very, very popular Rhode Island restaurant together. And when they were best friends, but then when they had a falling out, they had a falling out and it got crazy. It was like one got control of the Instagram account and wouldn't give it to the other one, but one got control of the LinkedIn account and wouldn't give her access to that. One had control of the bank accounts and wouldn't give access to that. Someone locks the other one out of the business. You know, just all these crazy things.
Physically locks them out.
Yeah, physically locked them out, like changed the locks on the business, like couldn't get into the business. And just it was just escalating. And the problem was our client would say, okay, let's go to the judge and get this fixed. And we're like, but based on what? Do you have any evidence you're more entitled to the Instagram account than that person is? I mean, you know, you're probably both equally entitled to it. So maybe we can go get you access to it. But then how do you share an Instagram account? You know?
Right.
So, I mean, there's just a million different problems that if if you had been creative with a corporate attorney to say, okay, in the event that this occurs, so and so who's good with Instagram is still in charge of the Instagram account, and both parties shall have access to the restaurant, and all of the things you could imagine. So much of writing a contract you learn in law school is imagining what problems could come up and then trying to put in place solutions in advance. Then you can go into a judge and say, look, I should have access to this Instagram account. It says right there. So it's really makes a huge difference night and day. So it's funny with the other litigators will kind of joke. I'm like, oh, got another one without an operating agreement. It's like, oh, it's just never good.
It's funny when you say that because I talk to clients and they go, the attorneys are asking us about all kinds of scenarios and situations that aren't going to occur. And I said, the reason that's brought up is one of the parties has dealt with that and knows it's an issue, and they want to spare you the pain of having to deal with that if it comes up in the future. And it's funny, like I think the really good attorneys like use their experience, use and say, okay, this is what could happen. I know it's not likely, but if it does happen, let's just agree how we're going to handle it so that we don't have to fight about it. Like I think and that sometimes scares people off when it comes to like calling their attorney. I'm like, no, call your attorney in these situations. I said an hour of discussion, yes, it's going to cost you. I don't know what your firm charges, but it lists anywhere from $400 to 2,000, depending on the size of firm you deal with. That money, that 1 hour will save you a couple hundred thousand in the future because you have to litigate something because you didn't decide what the scenarios were and how to document it now.
Here was one of the issues that came up in one of my cases was there was nothing in writing to say what the obligations were of each party to the business, right? So they have this restaurant, and if my client was to be 100% believed, she would tell you, I do all the work. I'm in there every day. I'm dealing with payroll. I'm dealing with the staff. This one's off on vacation doing nothing and just collecting half the profits. That's not fair. But then you say, but where does it say in writing she has to work at the restaurant? Doesn't say that.
Mhm.
I mean, you can say it's not fair, but there's not, legally, from a legal perspective, there's nothing in writing saying she has to be there 40 hours a week. So, that's the kind of thing you can put in writing to say, oh, this person's going to work this much, this person will work that much. Or if this person is working more than the other person, maybe their shares have to shift, or they have
Right.
to be paid more, or maybe they're salaried, and so it's not a problem if one person works and the other one doesn't. But all these things people don't think about when they're excited about their great idea to start a business. Additionally, another big one is you'll see parents gifting their businesses to their kids,
Yes.
selling
Yep.
their businesses to their kids, right? And
Mhm.
then you have the one kid who's kind of the most involved in the company. And so they feel like they're entitled to more. But then the kids who aren't there start saying, I think that one's taken advantage. I think he's getting benefits that we're not getting. That's not fair.
Yeah.
And that can create huge, problems within a family. So if it's spelled out that, yes, Jim is going to work in the company, but he's going to get X salary for doing so, that solves a lot of the issues that could be litigated.
You brought up a ton of stuff there that I see all the time. That the family dynamic of inside and outside the business. Everyone who's in the business thinks everyone outside the business is getting a free ride. And everyone who's outside the business is saying, why is so and so getting all this extra benefit? I would love to work in there and get all the extra benefit, not realizing that there's work involved with working in there. It's not they're sitting home doing nothing, collecting checks.
Right.
Having those conversations, again, it goes back to starting with a conversation and then documenting it. And putting your head in the sand and saying, oh, we'll just figure it out later on does not solve a problem. And when you're not there, like sometimes there's like, you probably see this, there's probably a dominant matriarch or patriarch that says they keep everyone in line. And when that dynamic leaves, it's the kids then say feel more emboldened to argue and step up because they're not going to be pushed aside or feel like they're going to get cut out because the matriarch or patriarch isn't there to be the arbiter anymore.
Right. And then, so the guy who's running the day-to-day operations goes and gets a great new, company car, and he says, well, this is important for the business. And if, the other uh, kids object, well, based on what? I mean, he's in
Right.
charge of running the business. He's made the business determination that he needs a
Mhm.
company car. Maybe you can convince a judge that that's unreasonable and he doesn't need a company car, but like, look at all the problems that, could
Right.
potentially come up that you have to deal with at that point. And but I think that's human nature. I actually kind of getting a bit off topic, but I see this a lot in my estate and trust litigation too, that
Mhm.
there'll be one kid who takes care of mom and dad towards the end when they're getting sick. And the
Mhm.
will comes out and that kid got more money. And that kid would say, well, yeah, I deserved it. I got more money. But the other ones say, no, that wasn't fair. They took advantage because they had control over mom and dad when they were
Right.
sick and they made them change the will. So it's that kind of thing where if mom and dad had had a clear estate plan in place in advance, then there would be no dispute about this. So just like,
Correct.
having a contract in advance just solves so many
Well,
problems.
you talked about too, like the fit of the. I see this all the time as well, and it's easily solved, but you have to have a conversation to be honest with yourselves. Is, well, yeah, we're going to split profits 50-50, but you talk like, well, I do more work and I do this, and my work's more valuable. And actually, we can use a family example or we can use friends. Um, every job that a company has isn't worth the same. Just because you guys are 50-50 owners, you may be doing, and maybe you are entitled to 50% of the profits. But if you're the CEO and you're in charge of sales and the market rate for those items are 250,000 and so is really handling HR and administration and they're very, very good at it, but the market rate for that might be 125,000. They're the best at both what they both do, but the actual market rate for that the compensation for that role is different. It is okay to agree that we're gonna pay different salaries based on what the market rates are, which actually makes your business more marketable because it shows what you really would have to replace the owners with. And you can still share the profits 50-50 because you both have put the same kind of equity and you're both taking the same risk. But on a day-to-day basis, you might be making different contributions based on market value, not on effort, but a market value. And
For
that
sure.
having those conversations really upfront and really helps the situation, and then documenting it. And it makes it really easy to one, not have litigation, or
Mhm.
make litigation easier to solve because you've got a framework to figure out who's right or wrong or who stepped over the line or not. And then,
No,
per-
well, two points on that note. So first is, then you could get creative and say, okay, we've agreed what the starting salary is for this job, and this one's market value is higher. But then you could also have something in the agreement that says, and this is the amount of raises per year that you're both going to get percentage of your salary each
yes,
year, unless the parties collectively decide that they want to do bigger raises or, something to that
right,
effect. So that you don't fight about, well, I maybe I was worth that much money back then, but now I'm worth more. You can think of that kind of thing in advance as
right,
well. I'll also make a plug for one of our USA guys, Zachary Weinberger of
yeah,
Remuneration Resources. We had to bring him in a family dispute where that was exactly the case. The some of the kids said the top guy in the company, that's a ridiculous salary for him. He shouldn't be making that much money. So we needed Zachary to come in and say, for this size company and what's going on at this company and his level of expertise, was that a reasonable salary? And for the other kids, was that a reasonable salary? And that gets very expensive. I mean, nothing against Zachary, he's worth the money, but I mean, that's the kind of thing that you don't want to spend money having to fight about later.
right, right.
Yeah.
Sally, this has been awesome. We're running up to the bottom of the hour. I want to, any other things that we didn't talk about or stories that you thought would be interesting? Because that's what we were going to do only is talk about interesting stories. But our planning, Sally gave me some ideas of things that we can actually, other things we can talk about. Any interesting story that you were ready to share that we didn't get to?
What's so tricky with regard to litigation is that although it's public record, like you could look up any of these cases I'm talking about in the abstract, I certainly am careful not to go into too much
Right.
detail. I don't need my former clients calling me like, "Hey, what are you doing talking about my case on the podcast?"
Mm.
So it's tricky. But I will say I guess a point that I would hammer home um, is that the kind of the kind of litigation you have and the quantity really I could affect the sale of your business. And I think that having an expert like yourself who can, not necessarily even from a legal perspective, but just from an outside perspective of somebody who's used to selling businesses, to be able to say, this is how your company is appearing to me based on all of these lawsuits that you have. And here's why we may want to get some of these resolved before we go to market with your company. Or we
Mhm,
might be able to say to them, hey, you know what? These are the little cases that they don't really say anything bad about your company. They're just things that come up. Let's go to market. We will have full disclosure of these issues, but completely be transparent about what the issues are, explain what we believe will happen. And if it's a big deal, maybe we agree to indemnify
mhm,
the buyer. That we say, look, if you're that concerned, if that's going to break the deal, we'll agree that we'll pay whatever the ultimate settlement is in this case,
mhm.
that we can close the deal. And I think that's a really important guidance that you can provide to your to clients.
Well, I appreciate that, and I think you're 100% right. Um, Now, we're going to wrap up now, but if anyone, hopefully you never need Sally services because you're not getting sued. But if you do, Sally is more than capable, and I would highly recommend you reaching out to her. Hopefully, it's a rare case, and you're on the right side, and you're being egregiously attacked, and she will help defend you. But if this situation does come, Sally, how do they get a hold of you? How do other people listening to this get a hold of you?
Sure. So the name of my law firm again is Cameron and Mittelman with T's, not D's, Mittelman. I'm licensed in both Rhode Island and Massachusetts. So I usually do work sort of Boston South and then all of Rhode Island. And my email address is my first initial last name, S. McDonald, like the fast food restaurant, at cm-law.com. But you can Google me and find me pretty quickly, Sally McDonald. But I'm always happy to just have, a free initial consultation with anyone who's even concerned that there could be litigation in the future, because as the theme of our conversation has gone, preventing problems before they happen is the best option. And a lot of times, what I do is not just go to court and deal in lawsuits. I deal with trying to prevent lawsuits. The call I was on right before this was with an attorney who I know well, and the conversation basically was, look, this seems like a stupid case to litigate. Don't you think that? And the other side said, yep, I think this is a stupid case to litigate. Let's figure this out so that we don't have to go to court. Let's help our parties get this resolved. So really, if you're having any kind of business dispute, even if it's not a lawsuit, feel free to give me a call. I'm happy to discuss.
Awesome. Thank you so much, Sally, for putting some time in with me today. Um, and I know this was not a typical type guest, but hopefully you guys agree with me. All this stuff that we talked, hey, we have a new guest.
Clifford had to make an
That's
appearance.
a sneak peek. That's our next month's guest on our podcast.
Your,
Between
your dog can ask questions of Clifford.
Oh yeah, I don't know if Hattie will be very friendly to smaller animals. She's a very protective of defending the domain here. Uh,
Aw.
so, but thank you. I hope you all agree that even though it's our normal, not a normal, typical guest we have on this type of podcast, there's so many things that Sally deals with that if you're aware of and can help proactively plan and proactively engage in solving these problems, will make your closing, your exit, your succession much easier and get the results you're looking for. So once again, thank you so much, Sally, and I'm sure you and I will be seeing each other many more times on our paths out in the networking trails.
Yeah,
But
and hopefully go for some wings soon.
absolutely, we got to get the crew back for that. So thank you very much for joining us.
Thanks, Greg. Have a great day.